Welcome to Q&A, Social Security Disability Today. This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call attorney Anthony Reeves. Is your host, attorney Anthony Reeves.
I've gotten this one before. People will come to me with this, and when they say it, it's on and popping. Because they've gotten their decision from Social Security, and it says, and they always come at me, and this is what they say. Just because I sit at home all day, and I'm working on a computer every now and then, doesn't mean I can work at a job for hours. And this is what I tell people. You're right. Well, why is it the judge neck started rolling, attitude, everything, gum started popping. I'm just saying, and I started laughing because I'm like, look, here's what, you know what it is? It's called a credibility determination. And this is why I tell people, be mindful of what you say. Hear me when I say this. During your Social Security hearing, the judge is going to ask you certain questions about your ability to sit, stand, push, pull, things of that nature. Think about what you do in a normal day in relation to how you answer that question. The problem is people don't do that. So they end up putting themselves in a funky situation for purposes of credibility. Let's talk about that for a second, all right? So let's say you sit there and you tell the court that, and they ask you, how long can you sit until you can't sit any longer? Listen carefully. How long can you sit at one time until you can't sit any longer? You say, I can sit for about an hour and a half. After that, I got to go lay down, and I'm done for about 3 or 4 hours, and then I sit up again. I'm done. Okay, so then, after you just told the court that you can only sit for an hour, and then you got to lay down for 3 to 4 because you're in such excruciating pain, you then tell the court that you have an active Facebook page, and you go surfing on the web, and you spend most of your day doing that, meaning most of your day, I have 3 or 4 hours a day. 3 or 4 hours a day. How many times you do it for a sitting? Well, I may sit, for a good while, Now, listen to how that sounds. You just told the judge that you can only sit for an hour and a half until you're in excruciating pain, and then you got to lay down 3 to 4. But then you come right back later and you say, I'm surfing the web and I'm on a computer and I do that several hours a day. See how conflicting that means? So what that tells the court is, you're saying you're this limited, but your activity is just telling them something completely different. And I always tell people, credibility is a powerful thing. Think about the context of what you say. So for instance, what can you do? I can barely lift 10 miles. I can't bend over, stoop, crawl, or anything. And then you come back later and say, well, I do a little bit of light house cleaning. Guess what light house cleaning is? Crawling, stooping, crouching, crawling, things of that nature. So all of a sudden, the court is not saying because you can push a mop, or that because you play on a video games, or because you're on your computer you can work. What they're saying is from a credibility standpoint that what your limitations are and what you're saying they are two totally different things. You are trying to imply that you are much more limited than what the records demonstrate. So that's why I tell people, be careful when you're describing what you can do, push, pulling, standing, walking, crouching, kneeling, lifting. Be mindful of what you do during the course of a day. So what does that mean? Well, what do? You don't sit there and say, I'm on the computer. See how vague that is? That don't tell me anything. I'm on the computer with you guys now. But you want to be specific. I'm on the computer. I have a laptop that I have in my bedroom. I typically will go surfing for about a good 10 to 15 minutes, but I'm either on my bed with my feet elevated with the pillows under my knees, or I'm on my recliner with my feet up in a hot pad on my back. And I only surf the web maybe 30 to 40 minutes. Then I got to close it up and I'll take a nap and then I'll come back later, and I'm doing that routine throughout the day. See how different that is from saying I spend the whole day or several hours in a day surfing the web? Because you've now gone from a general description, which basically gives the judge, and I'm like always a firm believer, You don't want to give people ammunition to figure it out. You don't want Social Security or a judge to figure out your condition. So when you say, I spend the bulk of my day surfing the web, and you don't specify what you mean by that, you're letting a judge, quote unquote, figure it out. Don't do that. All right? Don't do that. You want to be able to show, because if not, show specifically how you do those activities that corresponds to what your testimony was with regards to your specific limitations. So guess what? If you say you can only sit for an hour, and then you're down for like a good portion of the day because of how much pain you are, you want to say, if I'm sitting in a normal chair like this one, I'm probably good for about an hour. I could probably sit about 2 to 3 if I got a recliner and I could put pillows under my knee and have a heating pad on my back. But that's not sitting. That's reclining. And note, you don't want the court to try to figure out your limitations, because remember, the judge is not there with you at your house. So then when they're trying to look at the two, they'll understand, okay, the context in terms of what you're saying in relation to how limited you are. And let me throw out the extra caveat. Make sure your medical records support that you got to lay on your back with your knees elevated and so forth, because if the records look like your condition is not that bad, in terms of, they're like, well, wait a minute, he's got to sit with his legs elevated and he's in so much pain, got a heat pad, but he's only being prescribed Tylenol. Possibility the court, again, is going to look at you and say, I don't think your condition is as severely limiting as you're saying it is. It's limiting you, but not as severe as you're saying. So again, same overall argument. Be mindful, okay? The court is not saying that just because you do certain types of activities, you can go and do a job. Typically, it shouldn't. They're just looking at it from a credibility standpoint by saying, you are saying you're so much limited, but what you're telling us about your activity goes against that. Be mindful of how you answer those questions, and think about everything you answer in terms of what you do on a day-to-day basis.